The April 2026 Visa Bulletin is out, and before you get excited about the numbers you've been seeing online, I need to stop you right there. Because right now, a lot of people are looking at the wrong chart, and if you file based on the wrong chart, you could face rejection, delays, and legal complications that set your case back by months. So I need to make sure you understand one thing clearly before anything else in this video. Stay with me, because by the end of this, you will know exactly which chart applies to you this month, whether your priority date qualifies, and what you should be doing right now. Let's start with the basics. And I mean the real basics, because I want everyone watching this, whether you're brand new or you've been in this process for a decade, to be on the same page. Every month, the U.S. Department of State releases a document called the Visa Bulletin. It's the official guide that tells green card applicants whether their number is up, whether they can move forward this month, or whether they have to keep waiting. It's based on two things: your visa category and your country of birth. Now here's where most people get confused. The Visa Bulletin doesn't have one chart, it has two, and which one you use completely changes whether you can file this month. The first chart is called the final action dates. This one is the finish line. It tells you when your green card application can be finally approved and your permanent residency granted. Your priority date must fall before the cutoff shown here for your category and country before USCIS can actually approve your case. The second chart is called the dates for filing. This one is different. In months when USCIS determines there are more immigrant visa numbers available than there are applicants ready to use them, USCIS may authorize the use of this chart, and when they do, it can allow you to submit your I-485 application earlier, even before your final action date is reached. Filing early through this chart matters because once USCIS accepts your I-485, you can apply for a work permit and a travel document while your case is pending. That's a real and meaningful benefit. But, and this is the most important sentence in this entire video, USCIS decides every single month which chart applies. It is not automatic, it changes. You must check. And for April 2026, USCIS has officially confirmed that adjustment of status applicants filing inside the United States must use the final action dates chart, not the dates for filing chart, the final action dates chart. I'll say it one more time because this is exactly where people are making mistakes right now. For April 2026, if you are filing Form I-485 inside the U.S., your priority date must fall before the final action date cutoff for your category and country. That is the standard this month. Every month, you should verify this at uscis.gov before doing anything. Now, with that established, let's talk about what's actually in this bulletin, because there is genuinely significant news here. Before we get into the numbers, it helps to understand why the dates are moving the way they are right now. Over the past several months, priority date cutoffs across many categories have been advancing at a pace that immigration attorneys are describing as unusually fast. One likely factor behind this is that immigrant visa issuance abroad has decreased in recent months. When fewer visas are being issued through consulates and embassies overseas, more visa numbers may remain available within the annual limits. Under U.S. immigration law, those numbers don't simply disappear, they can be redistributed, and some of that availability flows toward people adjusting status inside the United States. The State Department's April Bulletin itself references recent administration actions and processing restrictions as context for why dates have been advancing. And the Bulletin also notes something important that you need to keep in mind as we go through these numbers, because the factors driving this advancement could shift. Whether demand rises or processing patterns change, retrogression later in the fiscal year is a real possibility. The fiscal year ends September 30th, 2026. That's your warning. The window is open. But it may not stay open. Keep that in the back of your mind throughout everything I'm about to tell you. Let's get into the employment-based categories, starting with EB1. EB1 covers priority workers, people with extraordinary ability in their field, outstanding researchers and professors, and certain multinational executives and managers. For most countries, worldwide, Mexico, Philippines, EB1 is current on the final action dates chart this month. That means visa numbers are available for final adjudication, assuming the rest of your case is ready and approvable. This is the strongest position you can be in. For India and China in EB1, the final action date has advanced to April 1st, 2023, 1 month of forward movement. If you're from India or China in the EB1 category and your priority date is before April 1st, 2023, visa numbers are now available for your case to be finally processed. Now, EB2, advanced degree professionals and people of exceptional ability, including national interest waiver applicants. And this is the headline number of the April Bulletin. For most countries, worldwide, Mexico, and Philippines, EB2 is current on the final action dates chart. Visa numbers are available for final adjudication right now. If you are otherwise eligible and your case is ready, this is a significant moment. For India and EB2, the final action date advanced to July 15, 2014, nearly 10 months of forward movement in a single bulletin. If you are from India in the EB2 category and your priority date is before July 15, 2014, visa numbers are now available for your case. For applicants who have been waiting years for this category to move, this is meaningful progress. For China in EB2, the final action date on the final action chart is September 1st, 2021. No movement this month, but if your priority date is before that date, your case remains eligible for final processing. EB3 covers skilled workers, professionals, and other workers. For most countries worldwide and Mexico, the final action date advanced to June 1st, 2024, a substantial jump. For Philippines, it advanced to August 1st, 2023. For China in EB3, the date is June 15th, 2021. And for India, the final action date remains at November 15th, 2013, deeply backlogged with no movement this month. EB3 other workers follows a similar pattern. Most countries sit at November 1st, 2021. India and China remain far behind at November 15th, 2013 and February 1st, 2019, respectively. EB4 covers special immigrants, certain religious workers, employees of international organizations, and others. For all countries, the final action date advanced by a full year to July 15, 2022. That's meaningful movement for everyone in this category, regardless of country. For EB5, the investor visa, most countries with unreserved numbers are current. China sits at September 1st, 2016, India at May 1st, 2022. And the set-aside categories, rural, high unemployment, and infrastructure, are current across the board. Now the family-based categories, and there is real news here too. F1 covers unmarried adult sons and daughters of U.S. citizens. This category advanced by nearly 6 months across most countries, one of the largest single-month advances we've seen in this category in years. For worldwide, China and India, the final action date is now May 1st, 2017. For Philippines, May 1st, 2013. For Mexico, February 15th, 2007. If your priority date falls before these cutoffs for your country, visa numbers are now available for your case to move toward final action. F2A covers spouses and minor children of green card holders. The final action date for most countries is February 1st, 2024. For Mexico, it's February 1st, 2023. There is a dual structure in this category, with numbers exempt from per-country limits and numbers subject to those limits. Your attorney can help you understand which applies to your situation. But the bottom line is that F2A remains one of the most accessible family-based pathways right now. F2B covers unmarried adult children, those 21 and older of permanent residents. This category advanced by roughly 172 days for most countries. For worldwide, China and India, the final action date is May 22nd, 2017. For Philippines, April 8th, 2013. For Mexico, February 15th, 2009. F3 covers married sons and daughters of U.S. citizens. This advanced about 3.5 months for most countries. The final action date for worldwide, China and India, is December 22nd, 2011. For Philippines, July 1st, 2005. For Mexico, May 1st, 2001. F4 covers brothers and sisters of adult U.S. citizens, one of the most backlogged categories in the system, but it still advanced about 5 months this month. For worldwide and China, the final action date is June 8th, 2008. For Philippines, February 1st, 2007. For India, November 1st, 2006. For Mexico, April 8, 2001. These backlogs run 15 to 20 years or more, but 5 months of movement in a single bulletin is unusual for this category, and it reflects the same underlying dynamics driving the rest of the bulletin forward. Now let's talk about the people who are in the strongest position this month and who is still waiting. If you are in EB1 or EB2 from most countries outside India and China, and your case is otherwise fully prepared and approvable, visa numbers are available right now for final adjudication. This may be the best position this category has been in for a long time. If you are from India and EB2 and your priority date is before July 15, 2014, you have newly reached the final action date threshold. Speak to your immigration attorney immediately. If you are in F2A and your priority date is before the cutoff for your country, you are in a favorable position for final processing. If you are in EB3 from most countries outside India, China, and Philippines, and your priority date is before June 1st, 2024, your situation has also improved significantly this month. Who still faces long waits? India EB3, still stuck in the early 2010s with no movement this month. China EB2, EB3, and EB5 unreserved, still significantly behind. Mexico and Philippines family categories, still still measured in decades for the older categories, F3 and F4 across all countries, still among the most backlogged pathways in the system. For certain nationalities, particularly those born in India and Mexico, the per-country caps built into U.S. immigration law create structural inequalities that no single month's bulletin can solve. Even historically, large forward movement barely shifts the needle for applicants who have been waiting 20 years. That is a deeper policy problem, and one worth understanding when you hear politicians and commentators talk about immigration reform. Now I want to talk about retrogression more carefully, because understanding this concept could save you from a very painful situation. Retrogression means the cutoff dates move backward. Instead of advancing, they regress, sometimes dramatically and with very little warning. It has happened before in this system, and the April Bulletin has signaled that it could happen again before September 30th, 2026. Here's why retrogression is such a threat right now specifically. The dates in April are advancing partly because of factors that could reverse. If conditions change, if processing restrictions are lifted, if consular demand spikes, if more applicants become ready to file, the surplus of visa numbers that is currently driving dates forward could quickly disappear. And when that happens, USCIS and the State Department will pull the dates back to stay within annual legal limits. The practical consequence is this: if you are eligible to file right now, or you become eligible next month or the month after, you should file as soon as you are legally able to. Every month you wait is a month where retrogression could close the window on you. Filing an I-485 when you're eligible locks in certain protections even if dates later pull back. Waiting and hoping for a more convenient time is a real risk. And one specific situation where urgency is especially high involves children who are approaching 21 years of age. The Child Status Protection Act, CSPA, provides some protection against children aging out of visa categories when they turn 21, but it does not protect everyone in every situation. The rules around CSPA are complex and fact-specific. If you have a child who is close to turning 21 and your family's priority date is approaching current status, consult with an immigration attorney immediately. The consequences of aging out can be severe and sometimes very difficult to reverse. A quick word for diversity visa lottery winners, DV 2026, because the deadline here is absolute. All DV 2026 entitlement ends on September 30th, 2026. After that date, no more visas can be issued under this program, no extensions, no carryovers, and numbers in this program can be exhausted before that deadline if enough selectees move forward quickly. If you won the DV lottery this year, do not treat this casually. Get your documents in order, work with a qualified professional, and move as quickly as the process allows because the clock is not flexible. Let me give you some practical guidance depending on where you are in this process. If your priority date is already before the final action date cutoff for your category and country this month, this is the moment to act. Speak with your attorney about whether your underlying petition is in order, whether all required forms and documents are ready, and what the next concrete step is for your specific situation. Don't assume that current status means automatic approval. It means visa numbers are available and your case can move forward if everything else is in order. If your priority date is approaching but not yet current, you're within a year or two of the cutoff, now is the time to prepare. Assemble your documents. Confirm your I-140 is approved if one is needed. Know exactly what you'll need to file so that when your date becomes current, you can act quickly. The difference between being ready and scrambling can cost you months. If your priority date is far from current, you're looking at many years of waiting on. There are still meaningful things to do. Make sure any petitions filed on your behalf are still active. Stay informed about monthly bulletin movements. And if your circumstances have changed, new employer, new job category, new qualifications, consult with an attorney about whether other pathways might be available or more suitable for your situation. If you are an employer sponsoring foreign national employees, April 2026 is a month worth paying close attention to. Some of your team members may now be in a position to file adjustment of status applications for the first time, particularly those in EB2 from most countries. Helping employees understand their options and supporting their green card process is both a compliance matter and a retention strategy. One more area I want to address carefully, and this is for people currently on H-1B or other work visas who are waiting for a green card. Having a pending I-485 application can create additional flexibility for many workers, particularly around long-term job planning and stability. For some applicants, there may also be options around job portability after a certain period of I-485 pendency. But the rules around this are detailed, depend heavily on your individual situation, and should always be reviewed carefully with an immigration attorney before making any changes. The point is simply that filing your I-485 when you're eligible to do so can open doors that being stuck in non-immigrant status status keeps closed. If you're approaching current status or you are current now, this is a conversation worth having with counsel. Here is the full picture of April 2026, said clearly and honestly. This is a bulletin with significant and, in some cases, historic forward movement across both family-based and employment-based categories. 65 categories advanced. EB2 is current for most of the world. Multiple family categories moved forward by amounts we don't usually see in a single month. These numbers are real and they come directly from the U.S. Department of State. But the most important thing to understand is that USCIS has confirmed for April 2026 that adjustment of status applicants must use the final action dates chart, not the dates for filing chart. Your priority date must be before the final action cutoff for your category and country in order to file or receive approval this month. And the forward movement, while real, is happening in a context that could change. Retrogression is a genuine risk before this fiscal year ends. If you are eligible to act, act now. If you're preparing, prepare quickly. If you're watching and waiting, stay informed every month because the situation is moving faster than it has in years. This system is complicated. It's slow. It can be profoundly frustrating. But months like April 2026, when real movement happens and real opportunities open up, are exactly why staying informed matters. Drop your category, your priority date, and your country of birth in the comments below, and we'll tell you exactly where you stand. We read every comment, and we'll be back the moment the May 2026 bulletin drops. Stay informed, stay ready. We'll see you in the next one.